are in listen-only mode.
Good afternoon, everyone. Welcome to the gunnercooke Pensions Law Update. I'm Ginerva Gatwell. I'm a pensions partner at gunnercooke, and I'm joined today by Martin Scott, also a pensions partner at gunnercooke. Martin and I are going to present to you today for roughly 40 minutes, and we're going to cover topical pensions issues that we see arising day to day in our practice. Whether your organisation is a large PLC, a small company, a private limited company, part of a group of companies, whether you are a charity or a trustee of a pension scheme, pensions will be relevant to your organisation from time to time, and we hope that most of the issues we touch on today will be of interest to your organisation. There's a facility on the screen for you to raise questions during the broadcast if you would like to, and at the end, Martin and I will try to pick up your questions if there's time remaining. I'm going to start by covering topical issues for pension scheme employers. I'm going to do a brief recap of the nature of the different types of pension scheme in the UK and then look at an automatic enrolment update. I'm going to speak to you about the changes to the annual allowance. We're going to look at how we go about making changes to pension scheme benefits, and then finally a look at the local government pension scheme. Martin will then cover some corporate and commercial issues in relation to pension schemes. He will look at TUPE, mergers and acquisitions, the pensions regulators' powers, and group reorganisations and how they impact on pensions. So we'll start with a brief reminder of the different kind of pension arrangements in the UK. Probably the most common type of pension scheme today is a money purchase scheme, also known as a defined contribution scheme. The nature of these schemes is that there is a guaranteed contribution being paid into the scheme by the employer and the employee. There is virtually no funding risk for the employer, and the employee's retirement pension is purely based on the amount of money in their retirement fund when they come to retire. Contrast this scheme with a defined benefit scheme. The nature of defined benefit schemes is that there is a guaranteed amount of annual pension paid on retirement. Usually the pension is calculated by reference to the employee's final salary or career average salary and their years of service. These schemes bear a significant funding risk for the employer. Employers have to ensure they contribute sufficient funds into the scheme during the lifetime of the scheme to fund the appropriate pension benefits. It's also worth mentioning cash balance schemes. These schemes combine some features of defined contribution schemes and defined benefit schemes, and your organisation may have a cash balance scheme. The nature of these schemes is that there is a guaranteed sum available at the member's retirement date. So there is some level of funding risk for the employer. It needs to ensure that there is sufficient funds as targeted during the member's service to be drawn on retirement. The final UK pension arrangements we wanted to mention are small schemes. There are still a very large number of small schemes in operation. As the name suggests, they are schemes with a small number of members. They need to have less than 12 members, and the schemes must satisfy various other criteria. And if they satisfy the small scheme criteria, those schemes have much greater flexibility in terms of how they may invest the pension fund. Small schemes are usually set up by owner-managed businesses, and we do deal with quite a number of queries in relation to these schemes and the flexibilities that they have compared to a normal occupational pension scheme. And finally, master trust arrangements. Master trusts are large umbrella pension scheme arrangements. They're usually defined contribution arrangements. There are a few defined benefit arrangements, but they are set up for a large number of non-associated employers. They're often provided by large insurance companies, and your organisation may be participating in a master trust arrangement. They have become particularly popular with automatic enrolment duties. So we'll look now at automatic enrolment and a brief update in relation to how this is operating now for employers. Automatic enrolment, as you may know, is the legal requirement on employers to contribute to a pension scheme for their workforce. Employees also have to contribute, and the duties relate to automatically enrolling employees into a pension scheme and automatically re-enrolling employees broadly every 3 years into a suitable pension scheme. Your workforce will be divided into various different categories for the purposes of automatic enrolment, and those categories will depend on the age and the earnings of each employee. And a lot of employers are finding that there is quite an administrative burden in terms of monitoring and reviewing their workforce from time to time to check which category employees fall into and therefore what your employer automatic enrolment duties are. Many employers have outsourced the reviewing and monitoring and administration to the provider of their automatic enrolment scheme. But nevertheless, even if you've outsourced the monitoring of the employee data, you will find that you do need to keep the insurance company and the pension scheme fully informed of all of your employee and worker data so that they can correctly handle your automatic enrolment duties. Something we see quite often and which raises some issues is that employers seek to write the automatic enrolment rules into their contracts of employment and terms and conditions of employment. And there are quite a few sensible reasons for doing this. For example, some employers decide that they will just take a blanket approach and contractually enrol all of their workforce into their pension scheme, and by doing so satisfy the automatic enrolment duties. And this system can work very well, but employers do need to watch out for the overriding statutory rules in relation to automatic enrolment and ensure that where their employees choose to opt out of the company pension scheme, for example, the employer still makes sure that it monitors and reviews those employees' status and automatically enrolls or re-enrolls those employees from time to time in accordance with its statutory duties, even where the employees have, for example, opted out of the company pension scheme. The opt-out feature is obviously a key part of automatic enrolment, and workers may opt out at any time. The important thing to remember is that many employers now will be facing their re-enrolment duties. If your staging date was in 2012, 2013, 2014, you'll now be facing the 3-year automatic re-enrolment duties, and you may be needing to review your workforce and work out that some employees may have opted out or may not have been eligible the first time you had to comply with automatic enrolment, and therefore you will need to be assessing whether and when you need to re-enroll such workers. Clearly, the focus of automatic enrolment is that it's very broad-reaching, and most employers will find that nearly all of their workers are covered by the automatic enrolment requirements. However, there are a few exemptions. If you have very young or very elderly employees, or your employees do not reach the relevant earnings threshold, then they may be exempt from automatic enrolment. If employees have recently declined membership of your pension scheme, they may also be exempt from automatic enrolment, at least for a period of time. If you are a genuine partnership business, partners in that business do not need to be automatically enrolled into a pension scheme. And companies with directors, even on contracts of employment, do not have a duty to automatically enrol certain directors. We'll now look briefly at the changes to the annual allowance. In our experience, this is affecting quite a few employers in the UK, and they are looking at ways of managing the changes. The annual allowance, by way of reminder, is the annual limit on the amount of pension benefits that an individual can build up each year. If they are in a defined contribution scheme, it's a fairly simple calculation involving looking at the amount of contributions that are going into that scheme from the employer and the employee. If an employee is in a DB scheme, there is a slightly more complicated formula involving looking at the growth in value of their benefits in relation to the year of service and the salary over time. It's important to note that the annual allowance covers all of an employee's pension benefits across more than one scheme if they have one during the year. Any benefits built up in excess of the annual allowance are subject to significant tax charges. So for many employees, there will be no desire to exceed the annual allowance. Now, the annual allowance has become an issue recently because the government has reduced the annual allowance limit quite considerably over the years. You can see on the slide there that the annual allowance was set at £255,000 before 2011, and it's been reduced firstly to £50,000 in April 2011, and it is currently set at £40,000 and has been set at £40,000 since April 2014. The annual allowance is further reduced for particularly high earners. So if you're operating a business with employees and senior staff who may be earning in excess of £150,000 in total earnings each year, the £40,000 annual allowance is further reduced down, potentially as far as £10,000. Also, if you have employees over age 55 who have started to flexibly access their defined contribution pension funds whilst still working, the annual allowance is reduced for those employees as well. So the annual allowance is catching many more employees in companies across the UK, either because they're higher earners, because they're flexibly accessing their pension, or because they're very high pension savers, for example. So what can employers do in relation to this change? The employers do not have to do anything in particular to address this change, but nevertheless, many employers are considering the impact on their staff. The first level of intervention that the employer could consider is simply to inform members of the annual allowance limits and the reduction in those limits, and leave members to make their own arrangements in terms of dealing with the annual limit. One employer that we've been working with has actually decided to offer members individual options in relation to adjusting their annual contributions and their annual benefit accrual to make sure that they do not exceed the annual allowance each year. A slightly more interventionist approach would be to consider amending your pension scheme so that in respect of all of your pension scheme members, you put a limit on their benefit accrual each year to make sure that in no case it will go above the annual allowance amount. The benefit accrual would then start again in the following year, and again the scheme rules would provide that the annual allowance will not be exceeded at any point. Finally, some employers, one which I've been working with recently, is also going as far as to compensate members for the lost pension contribution. So where members are reaching the £40,000 annual limit or the lower limit that may apply to them, the employer is devising a scheme whereby it will compensate members in terms of additional pay because the members' contributions, which are contractual contributions being made to the pension scheme, are being abated due to this annual allowance limit and the adverse tax consequences of that. If you are considering looking at annual allowance changes for your workforce, you'd need to conduct an employment contract review before making any decisions, and any proposals that you come up with should be considered from the point of view of potential discrimination risk in terms of your workforce demographic. We'll now look briefly at changing pension benefits. In the current economic climate, many companies and employers are looking at changing pension benefits, either because they are trying to comply with automatic enrolment requirements or because they are finding the pension arrangements are very expensive to support and they'd like to look at changing them where possible. Pension benefits can be extremely expensive for companies, and certainly companies will look at projects around changing pension benefits wherever possible. The first thing to note is that the law protects accrued benefits, and accrued benefits are all of those benefits that employees have built up in their pension arrangement up to today. This is statutory protection in Section 67 of the Pensions Act, and therefore it is extremely difficult for any employer to change adversely any pension benefits that employees have built up. There are some very limited exceptions. The first one being that if you obtain the employee's consent to changing their accrued benefits, you can do so, but it's very unlikely that any employee would consent to any adverse change to the benefits that they've already built up. And secondly, in certain cases, you can obtain an actuarial certificate of equivalence, which confirms that the changes you are making to accrued benefits result in no lesser value benefits for the members overall. But those certificates are very difficult to satisfy, and as a consequence, it is very unusual, extremely rare for accrued benefits to be changed. So what employers often do is look at changing pension benefits for the future. They may consider reducing future benefit accrual. For example, a pension scheme offering a 1/60th accrual rate may change to a 1/80th accrual rate, or may change to a career average accrual rate from a final salary accrual rate in an attempt to reduce the benefit formula and reduce the costs of the pension scheme. Alternatively, schemes may look to cease future benefit accrual completely and change, for example, from a defined benefit scheme to a defined contribution scheme. Changing future benefits is usually possible, but there are some legal hurdles that need to be considered. It's important for the employers and the trustees to look carefully at the pension scheme governing rules, and in particular at the amendment power. Some amendment powers do not permit changes to future pension benefits, or only permit certain changes to future pension benefits. For example, we've seen cases where even if defined benefit pensionable service accrual is to cease, the employees are entitled to the benefits they've already accrued to continue to be linked to their future growing salary increases. In extreme cases, some old pension scheme documentation does not permit any changes to future benefits that would be seen as less generous than the current benefits the employees are building up. There are ways around this though. With legal advice, it can be possible to make changes to future pension benefits even where the pension scheme rules would prevent this. The method used is known as extrinsic contracts, and this is where the employer seeks to change benefits in simple terms by looking at the employment contract and agreeing as a matter of contract with employees that their future pension benefits will be changed. There are several cases where this has happened successfully, in particular the BBC case a few years ago. In this case, the employer negotiated with employees to agree how pay rises would be affected in the future, but reached an understanding with employees that pay rises would no longer be pensionable. This case represented a very interesting way and creative way of looking at seeking employees' agreement to reducing the company's overall pension costs and pension liabilities going forward in return for some benefit to the employees in terms of pay rises in the future, albeit those pay rises wouldn't be pensionable. What we know from the case law in this area is that any changes to pension benefits need to be communicated very carefully and very sympathetically with the workforce. Employers have a common law duty of good faith, trust and confidence when they are dealing with employees in relation to pension changes. And there have been cases in the High Court in recent years where employees have challenged the way in which an employer has gone about making pension changes. So we would urge all our clients to consider quite carefully in advance how they are going to make a pension change and how they're going to communicate that transparently to their employees. It's worth also noting that many types of pension scheme changes require a statutory 60-day consultation period. Again, if you're thinking of making a change to pension benefits, it's worth seeking legal advice to find out whether the type of change you're making will be subject to a 60-day consultation period. I'd like to finish my section by touching on the local government pension scheme. We often deal with clients who find themselves as participating employees in the local government pension scheme, either because, as of right, they are the type of organisation that is required to participate in the LGPS, or they are a private sector contractor which has taken on a local government service and by virtue of that has to participate in the local government pension scheme. The local government pension scheme is a defined benefit pension scheme. It's used to be based on a final salary benefit formula. It's now based on a career average benefit formula, but it's subject to its own funding rules and its own contribution rules and liabilities. And it's fair to say that the contributions and the funding obligations are relatively significant for employers because of the nature of the benefits. Where private sector contractors are taking on local government services and having to participate in the local government pension scheme, they're having to do this essentially because they're governed by a range of policy and statutory background rules which require that the employees coming out of local government service are entitled to continued local government pension scheme benefits. Historically, the mirror image benefits may have been provided by the contractor's own broadly comparable pension scheme which mirrored the same local government pension scheme type benefits. But the government has made changes in this regard recently, and it is now more common for for contractors to actually participate in the local government pension scheme. So the key issues we see arising here are the risk-sharing provisions when a contractor has to participate in the local pension scheme. The first document that the contractor will need to sign up to, the employer, in other words, is the admission agreement. The admission agreement sets out the terms of that employer's participation in the LGPS, and usually the admission agreement has very limited scope for negotiation because it is a standard form agreement with the relevant administering authority of the local government scheme, usually a council, metropolitan borough council, city council. So it then becomes imperative for the contractor to agree separately in its outsourcing contract arrangements how it will seek to limit its liabilities and try, where possible, to protect itself against exposure to the wider local government pension scheme funding issues. Usually, the employer will need to provide a bond or some form of guarantee or indemnity in support of its admission. It's very important up front to set out how the cost of that bond will be met. If it's to be met by the contracting employer, then that needs to be factored into the cost of providing the services. When participating in the scheme, some employers look to cap the level of employer contribution rate they will need to pay to the LGPS during the term of the entire contract, and this obviously provides some certainty in terms of how much they will have to pay into the scheme whilst they are providing the service. Importantly, at the end of the contract for provision of services, the local government scheme contains various triggers when employers exit the local government scheme. The sort of triggers that are of concern are the ones regarding deficit payments, known as exit liabilities in the local government pension scheme. So again, it's important to agree up front how liability will be apportioned for any exit payments that might be owed by an employer when it ceases to participate in the local government scheme at the end of its contract term. Other issues that can arise are how to share funding strains in relation to early retirements or redundancies of employees during the contract period. This is where employees retire on or after age 50 or 55 on full pension rights or nearly full pension rights. This can put a strain on the required funding level of the scheme and can increase employer contribution rates. Sometimes employers have been able to negotiate that any additional costs of these type of benefits will be met by the outsourcing authority or local government provider. Another issue we've seen with some charitable organisations is that they have historically participated in the LGPS and continue to do so because they are required to do so because of the nature of the work they're carrying out. But the number of employees in the LGPS under their employment dwindles and reduces to perhaps 2 or 3 active employees. This can be very difficult to manage because, of course, when the last employee leaves the employer will have no further employees in the local government pension scheme, and that also triggers an exit payment, whereby the LGPS actuary will calculate if there's any funding deficit in relation to that employer, and that employer may have to pay a significant lump sum to the LGPS on leaving. Okay, that marks the end of my section, and please do raise any questions in the box on your screen as we go through the remainder of the presentation if you would like to. I will now hand over to Martin, who will take us through some commercial and corporate issues in relation to pension schemes.
Thank you very much, Ginerva, for that. Very interesting. I'm going to talk about corporate activity and pension schemes. In the last 12 months or so, we've had a couple of instances where corporate activity in pensions has made the news. There's been the BHS, I don't know what to call it, debacle scandal, where Philip Green sold his business and left the pension scheme under. And there was a settlement earlier in this year. And in the last couple of weeks, we've had a kind of a deal with the pensions regulator and the pension protection fund with Hoover, effectively dumping its pension liabilities on the protection fund. But before we get to that, I think we just need to understand some of the basics behind what happens on a corporate activity. And when I say corporate activity, I'm meaning here an asset transfer, a business transfer, or a corporate reorganization. And in both those scenarios, there's a couple of pieces of legislation which will or may be applicable. The first is the TUPE regulations, which, if anyone's from the employment field, they will instantly recognise and understand the TUPE regulations. They effectively provide what happens protection for employees when you have an asset transfer. And to understand, these will always apply effectively when you've got an asset transfer or on a corporate reorganisation. But you need to understand the difference between personal pension rights and occupational pension rights. The reason you need to understand those is because they're treated differently. Personal pension rights are treated in the same way as effectively all other employment rights. Effectively, there's no change. The new employer steps into the shoes of the old employer. If the old employer was having a pension contribution of 20% of salary, then the new employer has to provide 20% of salary. The situation is slightly different for occupational pension schemes. Occupational pension schemes, there is a pension exemption in TUPE regulations, which in the most part effectively says you can ignore pensions for TUPE. You may well be asking what's the difference between a personal pension scheme and an occupational pension scheme. I think probably the major indicator of it being an occupational pension scheme is you've got trustees and a trusteedom rules, whereas in a personal pension scheme, effectively what it is a contract between the employee and the pension provider, legal and general, prudential, that kind of thing. Okay, we said that most pension rights don't transfer, but there is a kind of wrinkle in there, which is surprising. We've still got this wrinkle, and as we say in the third bullet point, we haven't really sorted it out, despite the fact we've had the TUPE regulations since 1981. There's if you've got a defined benefit pension plan, like some of the things like Never would say, then if you've got special early retirement benefits in there or redundancy benefits, then there is the possibility that they may transfer. There's a couple of cases back in the start of the century, 2000 and 2001, involving health service type schemes, where the European Court held that some early retirement benefits did transfer. And then we had a kind of like intervening gap of about 10 years where people were trying to work out on that. We have a case, 2011, Procter & Gamble, which clarified certain aspects of it, but still left a lot of questions open. I think suffice to say, if you are involved in a corporate acquisition, then and the transfer employer has any DB level of contribution where you have special early retirement benefits, then I think you need to set some advice. On the second slide of the slide, we've got the Transfer of Employment Protection Regulations 2005, which potentially apply. They don't always apply. They only apply where the employees were in a occupational pension scheme. So that's the trust-based thing which we mentioned earlier. And here, unlike the TUPE regulations, the employer only has to provide a minimum level of contributions to a new pension arrangement. It can do that effectively if it doesn't want to provide a DB pension scheme, which probably absent the kind of like local government pension scheme, which Ginerva was talking about. Most employers will want to provide the DC money purchase going forward. Effectively, you've got probably two broad ways of complying. One is to match the same level of employer contributions. Alternatively, is to make contributions which are matched with what the employee pays, but up to a limit of 6% of salary. The bottom bullet point says that under these regulations, the transfer of employment protection regulations, you are able to contract out, which is sensible. I think one of the things I always find most bizarre about the TUPE regulations is even if the employer and the employee had reached a freely negotiated deal on what would happen on a transfer, that was void, presumably to protect the employee, but you can contract out of the as we call it, the TEP regulations. So you can have the next slide, Ginerva. So, a couple of things to look at if you've got a corporate activity. What to look out for as the kind of like the acquirer or the transferee employer. If the old employer had a DB pension scheme, then you need to be looking out for these special early retirement benefits we spoke of earlier, and you need to try and work out what level of pension provision you're going to go and provide going forward. You don't usually need to provide defined benefit pension schemes. You can go and provide that 6% match or something similar. You may well be thinking about getting an indemnity, especially if the old employer had some of these special early retirement benefits. Things are a lot easier if the transfer employees are coming out of the DC pension scheme. You just need to work out what those rights are, and you need to comply with the previous slide. You need to definitely comply with TUPE, and perhaps comply with the transfer of protection regulations if you've got an occupational pension scheme. You'll also be interested to know whether you're actually inheriting any restrictions which stop you from changing the level of pension benefits going forward. So you wouldn't particularly want some kind of restriction amendment either in the scheme documentation or the contracts of employment. And you probably want some limited indemnities and warranty protection. So if we could have the next slide, Ginerva. Okay, share acquisitions. In a share acquisition, the employer doesn't change, and the kind of like major difference between an asset and a share acquisition. In a share acquisition is you're interested in the entire history of the company, whereas in a business sale, you're only interested in the employers effectively who are working there at the time, and people who stopped working 5 years ago, you're not interested in. So a couple of kind of like things to think about if you're in a acquisition and the target has a DC scheme. You're going to need to just look at what the scheme is, what the powers of the scheme are, whether it has funny powers in there, what the employment contracts say. Is there anything grandfathered into employment contracts, which mean effectively you need to get the consent of the employer if you want to go and change the level of employer contributions going forward. And the final bullet point is, I think, is actually quite an important one. It's often overlooked because people usually, when you look at a company, are so focused, and this isn't necessarily a bad thing, in what's the current situation, actually forget that 5-10 years ago the company used to have a defined benefit pension scheme, used to participate in the defined benefit pension scheme. If you're inheriting the shares of a company, you actually do need to look at what the historic position was, as well as the current position. I've seen at least four occasions in the last 15 years or so where we've had a situation where the company being bought did actually suffer from that, and it came as a surprise to the seller that the historic position was important. If the target has a DB pension scheme, then the effect of a share acquisition is you buy the scheme effectively. So you inherit the whole scheme, lock, stock and barrel, even if it's got people in it who've nothing to do with any of the companies you're buying. I think in that scenario, you're going to need to get proper legal advice in what the scheme means for the business going forward. And you're also going to need to employ an actuary to actually work out what the state of the pension scheme is, what level of the deficit is, and that can be quite complicated. So there's a lot more to do when you've got a DB pension scheme and you're actually acquiring the whole lot. A slightly different level of interest and work to do is what happens if the seller's actually retaining the DB scheme, perhaps because you're just selling a number of companies outside the seller's group. The most important thing to look out for is the extent, if any, that the company you're buying is going to go and trigger a debt on leaving the group. The technical term for that is having an employer cessation event, which in turn triggers a Section 75 debt. Section 75 debt is a fancy way of saying a statutory withdrawal debt from leaving a group. And a cessation event effectively happens when a company ceases to have active members in the scheme, where other members of the scheme continue to have active members. So if you are unfortunately stuck in one of those scenarios, then you need to think of ways of anticipating that. There are a number of tools under the relevant employer debt regulations which allow you to manage that debt by effectively apportioning it or making the seller retain that liability. You could also try and seek an indemnity for that Section 75 debt or seek a purchase price adjustment. Again, it's probably a situation where you're going to need to get detailed legal help and actuarial help. We could move on to the next one, Ginerva. Okay, this is the kind of area where we've seen Philip Green and BHS getting involved with the pensions regulator. Pensions regulator has been in existence for about 12 years now, and it has had various opportunities to get involved in pension deals. It's got two broad tools it can use in the context of acquisition. One is a financial support direction, which I kind of call as a rich uncle provision. There's a concept in English law that a company is only liable for its own debts, even if there's somebody else in the corporate group to pay those debts. You can't go after the other company. What a financial support direction tries to do is try and drive a coach and horses through that. So it effectively says if you've got a poor employer in the group, and that poor employer in the group is actually a member of the pension scheme, but you've got a rich company elsewhere in the group which could perhaps meet the pension obligations of the poor employer, then the pensions regulator can, subject to it being reasonable and quite a few other steps, actually make that company responsible for the pension debts and obligations of another company. That's a kind of like no fault. You don't happen to need to have done anything wrong to get yourself in that scenario. You just have to have had the situation where you've got a poor cousin and a rich uncle. The other scenario is the contribution notice, which is where there is some element of fault involved, where somebody has been involved in a transaction. And it doesn't necessarily have to be a buying and selling of companies. It could be granting security or paying a rather large dividend. Anything that you do in the corporate sphere which reduces the ability of the company, which is an employer in the pension scheme, to actually meet its pension obligations. The pensions regulator can have a look at that and say, hang on a minute, you've done something, and as a result of that, the pension fund isn't now going to receive as much money as it would have done before the event, which gave rise to being interested in your pension scheme and can make everybody involved in the transaction personally responsible. But it's not just piercing the corporate veil in terms of the group, company A and company B and the rich company. It can actually involve directors or individual shareholders being personally responsible for the pension. It's mercifully rare, but the pensions regulator has, in certain circumstances, actually gone after individuals as well as companies. So I think the moral there is if you're doing anything as an employer and you've got a pension defined benefit pension scheme, you need to be aware of pensions regulator. And I think you also need to be aware of just certain statutory notification requirements that you've got. If you've got a DB pension scheme, you're meant to notify the pensions regulator if you're ceasing to operate a business in the UK, you have a change of control effectively if you're selling the business, or you're breaching some of your banking requirements. The pensions regulator is not just relevant on a corporate transaction. It's all forms of corporate activity, whether it was restructuring, as I said, or granting security, renegotiating your banking covenants. And you've got to think about what you're doing is how does it affect the pension scheme? And if you think what you're doing, no matter what it is, and however kind of like removed you think it is from the pension scheme, what you're doing does have a material effect on the pension scheme. You need to start thinking about the pensions regulator and whether or not you need to seek clearance from the regulator. And clearance effectively gives you some form of statutory protection against the regulator imposing its financial support directions or contribution notices. Effectively what you do is you go up to the regulator and confess all and saying, we're going to be doing this corporate activity, we're doing this, it will have this effect on the pension scheme, we're prepared to give the pension scheme X amount of money or a parent company guarantee or give it a mortgage, and if we do that, Mr. Regulator, will you promise not to use your powers? Another area where the pensions regulator get involved is in a scenario where you've got a kind of like a zombie company. You've got an employer which is probably otherwise viable, but because it's got an absolutely huge pension liability attaching to it, it really has. It's only existed to pay the pension obligations. The pensions obligations a yoke around its neck. Now, there are occasions where the pensions regulator and the pension protection fund is open to doing a deal and effectively shifting those liabilities over onto some employer out the group and effectively getting the employer with all the pension liabilities attached to it off the hook. They're not that common. We do get probably about 2 or 3 a year. There's always a price to pay for it. Unfortunately, because I think the regulator and the pension protection fund only have a limited amount of staff and resources available, they're probably only interested in doing it where the pension scheme is reasonably material in the context of the risk profile of the regulator and the pension protection fund. Unfortunately, if you're a small employer, you probably have less capacity to do one of these deals than a slightly bigger employer, and that, as far as I'm concerned, that's purely really a consequence of the size of your employer and how far you are on the pensions regulator. We had one of those just a couple of weeks ago where it was announced that the Prover pension plan, which was itself a reasonable sized pension plan, had effectively done a deal to let one of the underlying UK Hoover Group off the hook for its pension liabilities. So if we can have the final slide, Ginerva. Corporate reorganisations. I think this is certainly an area where it's the easiest one to trip up. Because if you're doing a big acquisition and there's a third party that you know what you're doing, you're probably thinking about pensions, you're probably thinking about all legal issues. What you can often get tripped up in is if you're just doing an internal organisation, you're moving companies from subsidiary A to subsidiary B. It's all in house. You think everybody's having, you know, as far as you're concerned, everything is going to be the same before and after for the employee. But there are, you know, a couple of trips which you might traps which you might get tripped up by. It'll probably take effect as a TUPE transaction, so all that stuff which we talked about on the first slide will apply. So you need to work out the rights. But one thing which is an unfortunate consequence of doing an internal organisation is that your employer is changing, and the old employer may have complied with its automatic enrolment duties, but the new one will effectively have to comply with the new obligations, even though the employees might have just been through an automatic enrolment procedure only days or months beforehand. So you can get yourself in a slightly bizarre situation where you had an employee who has just opted out of the pension scheme under auto enrolment. He or she is transferred to the new employer, and the new employer has to immediately start auto enrolling these new employees, and it has to write to the employer who's only just opted out and give them the opportunity to opt out again, and the employee may think it's already opted out and find itself automatically enrolled in the pension scheme, which they didn't want to do so. So you need to comply with automatic enrolment on an internal TUPE transaction. And equally, elephant trap is if the transferring employee has a DB scheme. Not only have you got to deal with the Beckman and Procter & Gamble and the special early retirement rights, which we talked about, you've also got to go and work out whether what you're doing is actually going to go and trigger a debt. If the scheme's still open to accrual, then you may well trigger one of these Section 75 withdrawal debts, and you're going to need to work out how you deal with that, because you presumably won't want to pay the price of the debt. Be very large. There are certain kind of like exemptions in the employment debt regulations to deal with that scenario. One of the ones which may particularly be applicable is something which is called a restructuring easement, which there's a clue in the name, which is available on a restructuring. So if you are transferring employees from A to B, you might be able to use it. There are a number of downsides to it, not least as it's quite complicated and it's quite narrowly drawn, and there's 7 or 8 steps you need to get yourself through. You do need the trustees on board with it. Technically, they don't need to consent to it, which in some ways is good. However, they do need to be satisfied that the new employer, is effectively as good credit worthy and has as much money as the old employer, and they can perhaps use that to object to doing a restructuring easement and prefer to either get the debt in or use one of the alternative means of avoiding a underfunding debt on a company coming out of the group, which require their consent, and consent usually has a price. So have a look at, see whether you can squeeze yourself into the restructuring debt. Talk to the trustees on it if the transferring employer does have a deep pension. And you've also got to think about the moral hazard provisions which we talked to earlier, the pensions regulator. If it's the case that company A, the transferor employer in the pension scheme, and it transfers all its assets and liabilities over to the new co, you've got to think about how it's actually going to go and fund its pension benefits going forward. If all the assets and liabilities have moved over to another company, how is it going to go and pay its pension benefits? How is it going to pay its pension obligations going forward if it doesn't have any money? So effectively going to need to have some deal done there to work out what happens, what's going to happen to the sale proceeds, if there are any. Do you need to involve the pensions regulator, because that could easily be in its moral hazard contribution notice territory. So that's a kind of like whistle-top tour of some of the areas where you might get tricked up on acquisition. One is if you've got historic pension liabilities, don't just look at the future if you're on a share sale. If you're on an asset sale, you've got to comply with not only TUPE, but potentially the pension protection regulations, and also got to bear in mind that your new company has got to go and comply with automatic enrolment. Just because some guy opted out with and the old employer, that opt out doesn't transfer, so if necessary they're going to need to opt out again. Watch out for unnecessarily triggering these statutory underfunding debts, particularly in a internal reorganisation. And if you're the acquiring employer and the old employer has a DB scheme, be particularly careful of special early retirement. And also, just bear in mind that no matter what you're doing, if you've got a DB pension scheme in the group, just think about the pensions regulator powers and what, if any, effect what you're doing has on the trustees of the pension scheme. So, those are kind of the areas where you need to look out for if you're doing an acquisitions. We know it matters because, we've had Philip Green. No one really wants to get themselves in front of a select committee. I think that was all I wanted to talk about. I'm going to pass you back to Ginerva, who's going to field any questions we have and just do a general wrap up.
Thank you very much, Martin. That was an excellent tour of the all-important pensions issues that need to be considered where companies and organisations are considering almost any form of corporate activity or reorganisation, and highlighted the commercial position that pension schemes take in many of the wider negotiations. Thank you, Martin. We have about 4 or 5 minutes remaining, and we'd just like to take a couple of questions, I think, in the time available. We have a query regarding automatic enrolment and salary sacrifice. We currently operate automatic enrolment as required by the legislation. We're considering implementing a salary sacrifice arrangement across our workforce. Is salary sacrifice compatible with automatic enrolment? This is a really good question. Salary sacrifice is increasingly common because it is a method of reducing the national insurance contributions that both the employee and the employer have to pay. So many employers do provide this option to their staff. In terms of automatic enrolment rules sitting alongside salary sacrifice, I think the important points to be aware of are that when you're looking at an employee's qualifying earnings for the purposes of categorising them for automatic enrolment purposes and paying contributions on their qualifying earnings, you need to look at the earnings after the salary has been sacrificed. So you look at the post-sacrifice salary when you are looking at what an employee's qualifying earnings are in terms of meeting the minimum contribution requirements for automatic enrolment. The current minimum contribution requirement for employers is 1%. That will be increasing to 2% next April, and finally to 3% in April 2019. I think also it's important for employers to be aware that they cannot require their employees to sign up to a salary sacrifice arrangement in order to remain in the automatic enrolment scheme. So any rules around that would be prohibited, and this feeds into a wider issue really about the rules against any prohibitive conduct by employers in relation to automatic enrolment. So I would just add there that in addition to any requirement requiring employees to commit to a salary sacrifice arrangement, which would be unlawful, employers should be aware that there are also other actions that may be considered unlawful if they are seen as disincentivizing employees to take up, or rather incentivizing employees to opt out of automatic enrolment, or putting in place any barriers to automatic enrolment. So the answer is that certainly salary sacrifice does operate well, even when you're an employer implementing automatic enrolment, and they can be run together. You may need a little bit of technical advice in terms of setting it up to make sure that your salary sacrifice arrangement is properly set up contractually, and that you're using the relevant data for automatic enrolment purposes. I don't know if there are any questions that have arisen on your front, Martin. We've got a couple of minutes left.
Just the one, Janelle. Does the pensions regulator have to consent to a takeover? That's the question. The short answer to that is no. You don't formally need the consent of the pensions regulator if you're selling a company or you're buying a company. So there's no formal consent. But what could happen is if you've got a transaction and the trustees get to hear of it, or one of the parties in the transaction decides to actually go for formal clearance application, or just make informal, communications with the regulator, is that either the regulator or the trustees could, depending on what their powers are or what the effect of the transaction is, threaten to, in terms of the trustee, use some of the powers under the trustee rules, perhaps to wind the scheme up and trigger a debt, and thereby make the transaction economically not viable. Or the pensions regulator, if it doesn't like what it says, could make very heavy threats and hints that should this go ahead, it's going to exercise its powers and make everybody involved in the transaction personally liable for debt. That would effectively amount to putting a complete embargo, or make people fundamentally reappraise what the transaction is going to be. I mean, if they don't like the price that the regulator's saying and they believe it will do what it says, or they don't like what the trustee says and it's a pension plan that's got some powers, you might find yourself effectively having the regulator or the trustees having some form of veto, which they've used in an indirect route, but they can't actually block it. All they can do is threaten to use whatever powers they have where relevant and where it's appropriate to force the recalcitrant parties to. I hope that answers that one. So I think that probably does us. I don't think we've got any other questions. If we have any other questions, we haven't managed to deal with them, please contact myself or Ginerva, or both of us, or your usual gunnercooke contact. Our email addresses are on the front page of the slides there, or get in touch with your usual gunnercooke contact, and we'll endeavour to get back to you if I can. So I'll just pass you to Ginerva, who may just have a general wrap up before we go.
Thank you, Martin. Thank you for listening today. We hope we've demonstrated the range of issues that are relevant in the realms of pensions law and regulation. And as Martin says, please do not hesitate to contact either of us or your usual gunnercooke lawyer if you would like to discuss any pensions related issues. Thank you.